the evening, although our next speaker actually understands Hebrew, but speaking the talk will be in English. So the next speaker is David Weber, who is a professor at Boston University School of Law, where he teaches, among other things, both civil procedure, but also corporate law, so it's a perfect fit. He, among other things, is also the author of a forthcoming book on Labor's shareholder activism, which is entitled The Rise of the Working Class Shareholder, Labor's Last Best Weapon, which will be published next year by Harvard University Press. So, David.
Okay, well, thank you very much, Leora, for inviting me to participate in this panel. It's an honor, and I very much was fascinated by the book, and I think that you are a particularly excellent guide to trying to navigate these very treacherous waters of trying to work out how do we deal with the exceptional, unique, horrifying aspects of the Holocaust within the context of a very mundane legal system using the exact same tools that we use to process tort cases and securities cases, et cetera, et cetera. And I think that the book really provides very great guidance to both the historical concerns and the legal concerns and how the two sometimes cohere and sometimes clash. And so what I want to do a little bit is, with my remarks, is to conduct a bit of a thought experiment that I think to some extent might be viewed as some of the historians' worst nightmare, at least as I understand it in the book, which is to treat the Holocaust litigation as if it were a perfectly ordinary lawsuit, like a tort case or a securities case, and compare it to lawsuits like that, and ask some questions about, well, how is it distinct from those types of suits, and how is it similar to them, and what can we learn by comparing this lawsuit to other lawsuits using very similar tools, and how was this lawsuit, if at all, able to navigate some of the special requirements, the conditions of the Holocaust, if at all. I say that at least for some historians might be a bit concerning, because one of the themes of the book is about how historians, there's been a lot of criticism of the Holocaust litigation, particularly from historians, though not exclusively so, because what it did was detract or distract from what one might call core aspects of the Holocaust, the genocide, and the things that we all associate first and foremost with the Holocaust, the Auschwitz, the gas chambers, the crematoria, etc. And it distracts from that core narrative by emphasizing economic crimes, which tend to be viewed as more mundane, and indeed, I think it's fair to say are. And so it seems it's something that I hadn't thought about all that much before reading this book, but if you think about something, a catastrophe like the Holocaust and the core crimes of genocide at the heart of it, it is also almost inevitable by definition that around that core there's going to be a broad swath of ancillary crimes that are more mundane, like life insurance policies that never get paid, bank accounts that get opened and never get honored, and then ranging towards more, slave labor, which I think moves back towards the core of what we think of as the Holocaust, but maybe isn't quite at the center of it, right? And so it's invariable that you're going to have a litigation that's going to pursue those kinds of crimes, especially crimes pursued by corporations and the necessary tools that need to be brought, like the civil action, the class action, to be brought to remedy those issues. There is this question of, does it just detract and distract from the main story, the main historical narrative, by focusing on life insurance policies and confiscated bank accounts? Now, I think that is a very legitimate and understandable concern, the importance of trying to keep the Holocaust in its appropriate place within history. But at the same time, right, there are very serious legal questions and other fairness and ethical questions to be raised, including the fact, if any of us had heard that some bank went around opening millions of bank accounts and then just took the money and never paid, or wrote lots and lots of life insurance policies and collected the premiums and never paid, we would all rightly be outraged and expect and demand. It would be obvious that you should, of course, run to court and do something about that. But then when it comes to the context of, well, this is the Holocaust, suddenly it gives us pause for some reason. And yet, on the other hand, what's the logical conclusion of that line of thinking? I mean, she doesn't say this, and the historians don't, I don't think, come out and say this, but I mean, is the logical conclusion of that line of thinking that these lawsuits should never be brought because they're a distraction? That too would seem to be an injustice, particularly it's sort of, first you're the victim of such a crime, and then there's almost a sense like, well, we really ought not do anything about it because it's, distracts from the worst crimes that took place here. So it's a very, very complicated set of issues and of concerns. And it explains some of the preference that Liora describes in the book for, at least among certain of the historians and others, for criminal law, which has a certain moral valence to it, and an adjudication and a legal opinion, which gives us a final result, a liable, not liable, guilty, not guilty, etc. So, nevertheless, these lawsuits happen, and if they were going to happen, they were going to almost inevitably, what else could they do but go into precisely the place that Liora describes them to go, which is into the available tools in the form of the class action and in the form of transnational litigation. And by the way, by many of the same lawyers who bring these far more mundane class. I looked up the lawyers who were on the settlement. First of all, there was, of course, Bert Newborn, who happened to be, this is not particularly important, but was both my constitutional law professor and my evidence professor. But more importantly, the law firms that were on those cases are law firms that their bread and butter is to bring securities fraud class actions. There weren't special lawyers brought in to keep it distinct, right? You actually want the people who really use Rule 23b3 and who know how to certify a class action and who know how to find the money inside complicated financial institutions. Those are the lawyers you want bringing these cases, and appropriately, those are exactly the lawyers who did bring them. So in a sense, though, violating a little bit of this taboo, it's important to recognize, well, this was a real lawsuit, and it had all the strengths and weaknesses and complexities of a real lawsuit, and of a real kind of business and tort lawsuit. And so what I'd like to do is spend the rest of my time just sort of ticking through some of what I think is both comparable to and distinct from these more ordinary litigations, to give us a sense of how the Holocaust litigation moved through the system. So I want to talk about legal limitations, I want to talk about the settlement and the damages, a bit about the lawyers, and then, of course, to touch ultimately on the histories that were produced, which I think Liora is quite right to emphasize as a truly unique and very important product of these lawsuits. So I'll end with that piece on the historian. So first of all, treating this again as an ordinary lawsuit with real lawyers and real legal limitations. There were real legal limitations on these cases. Liora points out that multiple federal courts had ruled that the statute of limitations had expired on bringing these lawsuits. The same federal courts had ruled that a 1991 treaty establishing the final borders of Germany had extinguished international claims of the type that were brought in this case. And so there were very significant legal barriers to the plaintiffs. And in fact, this discussion, it doesn't match perfectly onto it, but it reminds me very much of a discussion that took place in a Supreme Court case called Amchem. Now, Amchem, which was a legal opinion written by Justice Ginsburg, dealt with the asbestos cases in the United States. There were millions and millions of asbestos cases, people who had gotten sick with all sorts of cancers and asbestosis, etc. And it broke the legal system in the United States. I mean, it was thousands and thousands of cases. People went years. Many people died waiting for the lawsuits to be settled. And what happened in this Amchem case was that the plaintiffs and the defendants reached a settlement. And the complaint, the answer to the complaint, the motion for a class certification, and the settlement were all filed as a package on one day. And the question that the court faced in that case was, how should we think about whether to certify this class under Rule 23? how should we think about it in the presence of an actual settlement? We have people who are dying, people who are sick, money on the table. How should we think about that? And in a somewhat, I think, surprising but very important decision, the court ultimately ends up throwing out and refusing to certify the class action. And it's worth it to ask why. The reason was that Justice Ginsburg was concerned that there were sufficient legal issues that this could never really be certified as a real class action. I won't get into the details on it, but it could never really be certified as a real class action to go to court and to be litigated. And if not, then the concern was that you would have a neutered class. That is, you would have a class that was settling a case that didn't have the real leverage, the real legal leverage, to threaten to go past settlement. And therefore, the concern was you would get a lowball number. You would get, the settlement would be too low because there wasn't any legitimate leverage on the part of the plaintiff's lawyers. So that reminds me a little bit of the situation, of the posture of this case, which must have been in the room when those lawyers are sitting around negotiating a number, right? Which is, you're the German and you're the Swiss bank representatives, you know that you have extremely strong statute of limitations arguments that you can persuasively say to the lawyers across the table, if you ask for too high a number, you could get zero, right? That sort of thing. And that undoubtedly must have shaped the settlement, the scope of discovery. And there were, I looked up at some of the information. There were 6.8 million, just on the Swiss bank case, there were 6.8 million Swiss bank accounts. Records had been destroyed for 2.7 billion of them, were just gone. Ultimately, the number gets narrowed down to somewhere like 36,000 accounts, okay? And the damages were based on, assessments of those particular accounts. So let's talk about the damages for a minute, right? It's very hard to just evaluate a number in the absence of anything. $6.25 billion, right? What do we make of just a number like that? $2,500 to $7,500 per slave laborer. $800 million for those who could claim compensation for a bank account that had been taken. Well, so what are these? Is there anything that we can learn from these numbers? First of all, I would say, and again, I'm mindful of the historian critique, and even feel myself sort of, as I'm saying it, asking, should we be thinking about this way? Is it comfortable to mention the fact that the settlement value is somewhere between the Enron and WorldCom settlements, which were the two biggest securities fraud class action settlements? They were terrible things that happened at Enron and WorldCom, but they were not the Holocaust, right? So you have, on the one hand, a significant settlement, which Liora points out in the book, is meaningful even on an individual level, particularly to victims living in the Soviet Union who, some of these dollar sums may actually have been meaningful. But here too I want to compare it to general business litigation because it ties into the fact of settlement versus the fact of a verdict or a judicial opinion. And how so? In my world, in the business litigation world, the reality is that cases, we're so used to this, it's not, cases always settle. The plaintiffs, this may be a little bit more controversial, plaintiffs never get close to full compensation in these cases. And typically, again, to put it perhaps in somewhat crude terms, the value, the dollar sum is always viewed as a proxy for liability, right? In the absence of a judicial opinion, the dollar sum substitutes for some kind of judgment about liability. And in that sense, it's very hard to go and say, is it enough, is it not enough? It's certainly not enough. But in that sense, it was enough in the ballpark that I think it did convey a certain kind of message. You look at a settlement number like that, and if you weren't thinking about the historical context, but we're just looking at it in an ordinary lawsuit context, you would say, okay, there was real liability here somewhere, and the defendants just decided to settle the case for those reasons. Lawyers and lawyer fees. This always comes up. It's what should the lawyers in a case like this get paid, right? This too also seems like something that people don't want to think about or talk about. In fact, this is another point of interesting point of distinction, I think, with ordinary business litigation and tort litigation and what happened in this case, which is that the lawyers got a fee of between 1 and 1.5%. These are contingency fee cases, between 1 and 1.5%. I didn't know that until I looked it up. And that's the lowest fee I have ever heard of in any situation. It was still many millions of dollars. But there is never, the lowest fees that you hear of in cases are typically around 18%, 22%, 20% fees in billion-dollar cases.
These are the lowest.
Yeah. These are typically the lowest percentages. Yes, 18% is a low number. And you typically only get a number like that when you have a very sophisticated investor lead plaintiff that can negotiate fees. Okay. And some of these fees were actually just donated in the end. Not all of them, by the way, but some of them were. A couple other points about deterrence and compensation before I even get to this question of the histories, which is what I really want to spend the rest of my time on, or the rest of the next 12 seconds on. You know what? Maybe okay. Let me jump to the histories. To me, it's the histories that were produced that are truly extraordinary and that distinguish what happened in this lawsuit from what would happen in an ordinary litigation. And it's distinguishable not by shades of gray, it's literally just the opposite of what normally goes on in such lawsuits. Okay, if you look at lawsuits of the kind that the lawyers who brought this one normally bring, it always follows the following pattern, whether it's a securities fraud or a tort or whatever it may be. It almost always follows the same pattern, which is that the plaintiffs and the defendants agree that all of the facts are going to be kept confidential, with a certain, except for all the documents that get turned over, and essentially it turns the lawsuit into a kind of conspiracy against public information leaking out. Why do these deals happen? The defendants don't want the information disclosed publicly because it makes them look bad. The plaintiffs need the information for their case, and the lawyers are paying for that lawsuit, and even if they have perfectly good grounds to argue that the company has no basis for maintaining the confidentiality of these documents, they think rationally, why should I spend the money to litigate that issue? The company is willing to give me all the documents that I need to make my case, as long as they're produced under a confidentiality agreement. And so I'll get what I need for my clients, okay? I'll get all the information I need, and that's it. That's how all these lawsuits happen. As it happened in a different context, a couple of colleagues of mine just published an op-ed, I think in the Washington Post or the New York Times last week, about confidentiality agreements in sexual harassment cases in the United States, and how so many of these perpetrators are able to go on with their conduct because the information never comes out to public light. So here, right, so that's what normally happens in these cases. Now, in this case, we know that these exhaustive histories were produced, historians were invited in, documents that they could never otherwise have seen, they were given access to, and these histories were written. Now, if I were to interpret this the same way I would interpret any other lawsuit when there's non-monetary compensation, right? Like a corporate governance form or some nonprofit entity that gets created to deal with the health effects of whatever negative thing. I'm right. Typically, right, that it would be interpreted, I guess, in a sort of law and economics bent as a sort of implicit trade-off. That is, that the plaintiffs gave up some compensation, some dollars, for this other form of compensation in the form of histories. One might view this, I think, appropriately as the victims paying for the histories in these cases, and if you add the value of the histories into the total dollar settlement, etc., you could think about it in such terms. But there's an implicit trade-off there, and there's something, I don't know. I mean, one would think that most of the plaintiffs, given that their lawyers sought this and that this was negotiated, were fully supportive of this. and on some level wanted these the files opened and written about and exposed. And so in some sense, this really did distinguish these lawsuits, and comes back to where I started with the whole question about the fraught historical questions that Liora guides us through so well in the book. And so ultimately, I think, Liora's book makes this very persuasive case, at least persuasive to me, that that this was the way that the Holocaust litigation had to go, and that viewing that the mere fact of settlement, we shouldn't fetishize legal opinion and an adjudication over a settlement, that the dollar sums were meaningful, that the histories that were produced were also meaningful, and that overall, in some sense, I think that the system, though imperfectly, was at least able to, that this lawsuit still stands out from other lawsuits brought in exactly the same way, in ways that I think are meaningful and important, and that are really, I think, teased out and highlighted in Liora's excellent book. So.